Hello, good afternoon, and welcome to the QED lunch debate on legislating European gambling, what's next on the EU agenda. My name is Laurie Korpi and I'm International Legal and Research Director at Gambling Compliance based in London. We've been following the European gambling debates closely over the years, and it's a pleasure to be invited to speak at this event. I've just been charged with some housekeeping matters, and I've been asked to introduce some introductory remarks to set the scene for the debate. Firstly, I'd like to remind speakers and guests that today's event is on the record. There are journalists in attendance, and the event is being recorded, and the speeches will be published on QED's website. Secondly, today's format will involve each speaker delivering a 10-minute speech, then followed by a discussion and questions. On questions, there's cards floating around, so please feel free to fill them out, and I can read them out. And there's also an evaluation form to fill out at the end. Since I've been asked to give some introductory remarks, I thought it might be useful to try and provide some context and map out how we got to where we are today. In many ways, it is an impossible task to do in 10 minutes, but it could be summed up by the notion that over the years there's been an absence of Europe in the gambling debate. This has resulted in the picture of online gambling we have today, which is a patchwork of regulations with a clear trend towards point of consumption legislation. And with this patchwork, there are differences between member state regulations, as well as differences in licensed numbers and products European consumers can access, as well as varying consumer protection measures and practices. As you can see, legal license offers differ from hundreds of operators in Italy offering a suite of games to 3 operators in Poland offering just betting. One consequence of multiple European markets and the cross-border nature of online gambling has in recent times been the use of bilateral agreements as a cross-border regulatory tool. This can be seen through agreements made by Danish, French, Maltese and Italian regulators, among others. Yet another consequence of the current treatment of online gambling has been that member states have enacted legislation which seeks to ring-fence their markets. This has been mainly through payment or website blocking laws. And also it involves blacklists or blocking lists, and yet again, these restrictive measures, there are vast differences on the application on the ground in member states. And also the effectiveness of these restrictive measures has been questioned from EFTA member Norway's evaluation of payment processing regulations or the experience of Italy with website blocking. With the differences between gambling regimes and claims that some national rules breach EU law, another consequence over the years has been litigation, with the main forum of debate at the European level before the Court of Justice. As you can see, there are close to 20 years of gambling cases being referred from national courts to the CJEU, with a long line of case law having been and continuing to be formed. But I shouldn't overlook the Commission and its launch of infringement proceedings during the 2000s, questioning the compliance of some member state regulations. Here you can see there remains a number of infringement proceedings formally on foot, and I'm sure we'll touch upon this in today's debate. I should also mention complaints lodged by the industry with the Commission. As of last month, there were close to 80 complaints lodged, with the list, like the ECJ's case law, said to be growing. So, up until recently, a consequence of how the EU's online gambling markets have formed, and having the Court of Justice the main forum for debate, while having clarification on some issues and laying down principles such as the discretionary power of member states, the non-mutual recognition of gambling licenses, the legality of monopolies, and the need for consistency and transparency in gambling policy. Uncertainty has remained since the Court can only adjudicate on questions referred to it. Step in the European Commission and Commissioner Barnier. Under Commissioner Barnier, we've seen the forum of debate shift, as it were, from the Court away from the court, I should say. The Commission's consultation, Green Paper, and subsequent communication and action plan has thrown a spotlight on 5 priority areas: compliance with EU law, cooperation, consumer protection, fraud prevention, and the integrity of sports. The question of how action from the European level can add value has become key to the current debate. We can see this in the action plan, which outlines a number of areas where European intervention should be explored, be it through a recommendation on consumer protection, one on responsible advertising, or the possibility of common gambling standards for equipment, I should add. And finally, while there's been a notable shift in the European level activity from the Court to the Commission, I should note an apparent shift in language from the European Parliament. If one looks at the so-called Schaldemose report from the former Parliament in 2009, perhaps some key takeaways were the word subsidiarity, or the phrase, a pure internal market approach is not appropriate in this sensitive area. Fast forward to the so-called Kreutzmann report from 2011, new key takeaways might have included the words active subsidiarity, or the phrase, in some areas there would be clear added value for a coordinated European approach. So the obvious question is, what is next? And to help throw some light on this and explain what is next on the agenda, I'd like to invite Mr. Ashley Fox, MEP and Rapporteur on online gambling, to deliver his speech, and then we'll hear from Ms. Charmaine Hogan, Policy Officer, Online and Postal Services at the European Commission, Mr. Martin Hager, Director of Regulatory Affairs, EGBA, and Michael Bay Yorsel from the Danish Centre for Gambling Addiction.